This is a very big statement, complex grammar, but yes, in essence, yes. Okay. Starting a new business. Okay. Starting a new business is the simplest definition of a startup. But then starting a new business, it is just not new business, it has to be new idea for the business also. If you start a grocery shop tomorrow, it won't be a startup. If you start a bookshop tomorrow, it won't be a startup unless you have some uniqueness there, a unique idea there. Okay, so a startup is where you have a new idea, a new offering. It can be an existing business, but you offer something new there, a new model, business model, or new product, new service. In that, for creating a startup, you definitely need to have that idea. Then you will need a passionate team. Obviously, you will need some systems and some settings that you need to do. So the people
you have
process.
been the co-host.
Okay. So all this can be help you to create a startup in very, very basic way. So startup is creating a business with new idea, new offering. And then it should have a good potential to grow, to make a big business. Now, this is all very good in telling in theory. Doing practically, it's a lot challenging thing. And for that, you need to have a very good idea to start with. And good idea is the one which solves a problem. So someone who can solve a problem can become an innovator. Hello, now are you able to hear me?
Yes, sir.
Okay, thank you. So we just saw startup needs to be a good idea and solve a problem. So when we are solving a problem, you can become an inventor. So who can become an inventor? Anyone who solves a problem can become an inventor, or he or she is an inventor because they have solved a problem, they have found a new way of doing something and found a solution for a problem. So can you become an inventor? Do you need to be an engineer to become an inventor? Do you need to be a scientist to be an inventor? No, anyone can become inventor. As I showed you, even my two children are inventors. They have solved a technical problem. Okay, they are not scientists, they are not engineers, they are not even graduate, they are not even completed their school, but they can do it because uh,
Okay.
yeah. So anyone can become inventor. Just you need to have confidence that you can solve a problem. So I have just put here who can become inventor. Even this bird is creating a tool, finding innovative way to get their prey, and even they can be inventor because they are solving their own problem. They are finding their solution. And why they have to do it? If that crow has to eat, it has to find prey, it has to find, innovate, make tools, get it. Otherwise, it will be hungry. So, what is it for the college student, researcher, academicians? Why they should be innovator? Okay, I think my screen was not visible, but you can always tell me. Is screen visible now?
Yes, sir.
Yes, sir.
Was it not visible earlier, few minutes back?
Yeah, actually, it's not visible, sir.
Then please tell me some issue. I think somehow sharing is going. I'm missing the sharing, or some settings are changing in between because roles are changing. So if something is missing, please let me know. I may not be able to see your chat continuously.
Yeah, okay, sir. Thank you.
Yeah.
Yeah.
So who can be inventor? I was just showing. I will just repeat this part that even uh, a bird can be inventor because it needs to feed itself. So why you need to be an inventor if you want to create a startup? Why you need to be an inventor? I have a slide for that, an interesting one. Okay, so it is said is necessity is mother of innovation. Anyone who knows this clip?
पूरा नहीं कौन मदद वाली
Yeah, Swapnil Gaikwad, can you please unmute yourself?
गलती हो गई अपन अनम्यूट कर
Thank you, Swapnil. Yeah, so we were seeing why to innovate. It is necessity is mother of innovation. And mother means माँ. मेरे पास माँ है. If you have the necessity, innovation will happen. So if you have a problem, if it is your problem, if you are trying to solve it, you will find the solution to that. And there are some easy steps to become innovator. I have just listed it here. I think you can read it. Any doubt on this slide? I hope these steps are very clear to you. What you can see here, you can unmute and tell, no problem.
You have given a scope to what you can make it as an innovator.
Okay. Yeah. I have written here easy steps to become an inventor. And actually there is nothing, because there are no easy steps. Okay. There are no easy steps. There is not like you attend an 1 hour training and you become an inventor. It doesn't happen like that. You have to take hard effort to identify a problem, validate it, and then solve it. Find solution and finally implement it. So there are no easy steps. Hard work is required. And then only you can become an inventor. But one important thing I will like to tell here, one should have sufficient knowledge. Okay. So even that is not required. One should have the understanding of problem, because many times we try to solve a wrong problem. One another important thing I would like to share before jumping in the core part of IP is why creativity and innovation, and from where, yeah, innovations happen accidentally, but actually then they never happen accidentally. Okay, someone is actually working, thinking on that, and all of a sudden, solution appears in front of them, because they are thinking. If same thing happens with someone else, they will not even notice it. So you need to keep thinking on that. So a very important shift required these days is, in academics, we are taught right from our school that there is one question, one answer, only one correct answer. And if you give that correct answer, you get 100% of mark. But when you come to the business world, when you come to the actual corporate thing, you have to solve real problems. One question may have multiple answers. So one question may have 3 answers, one question may have 10 answers, and all answers can be correct. It is not like one question, one answer, and then only 100% mark. All answers can be correct. All answers may be very different from each other. Important thing is not the answer. Important thing is to solve the problem. And then that's why creativity and innovation is becoming a necessary skill for all the leaders, business leaders, technology leaders. And that's where this creativity, innovation required. And you can put effort in thinking, finding the solutions. When you find the solutions, obviously all these solutions can be protected with intellectual property. So we'll see now part of intellectual property for startups. If you are thinking of startups where you can use it. So we'll start with the basics of intellectual property, IP or IPR. So when we say IP, most of time IP is referred in terms of patents only. But patent is only one part of intellectual property. There are many different ways of intellectual property to protect your idea, protect your business. So first one is patent. Patent is for any technological improvement, technological enhancement. So if we make any enhancement, any new technological advancement, it can be protected by patent. It can be a product, it can be a process, or it can be a software also. Even software concepts can be protected by patents. The algorithms basically can be protected by patent. So patent provides very strong protection on technology side. But patents are limited for 20 years only. So you get protection for 20 years. After 20 years, anyone can copy our idea because it is a 20-year-old technology. And government gives most of these protections are provided by government. You have to register this IP with government. So Either we can have a patent, or we have patent is for technology working of a product. We have another thing called as design. Design in India called as design registration, or in US it is called as design patent. So it is for outer shape of the product, not the technology, but only for looks. So what is this product you can see here? Can you identify the product shown here as a design?
Car.
Yeah, which car?
Or nano.
Nano.
Yes, it is a
Nano.
nano car. You can identify it very easily because of its unique shape. Okay, so if you have developed a product and it has some unique shape, even that shape can be protected without any technological advancement. Then third is copyright. Okay, copyright, most of time we hear in terms of novels or music or movies. Okay, but copyright can be applicable to many other things. For startups, it can be website, any literature, or your website or your literature that you have published, or any manuals that you have prepared, or any advertisement that you have created, or any images that you are using. All these things can be protected with copyright. Then next is trademark. So trademark we generally call as a logo. So trademark identifies who is the provider of goods or who is the owner of that particular brand. And a trademark is very important when you create a startup, because finally people know your product by the name. Okay, like if I ask how many of you know Paytm, I believe everyone must be knowing Paytm. But do you know which is the company offering Paytm? Paytm is brand name. It is a trademark. It is not the name of company. Like Nano is a name of product. Tata Motors is the owner of that product. Same way, Paytm is a product. Some other company is owner of that.
197 communication.
Yes, sorry, can you please repeat? Yeah, so
197 communication.
correct. So that is the power of trademark, because you get known in market with that trademark. Okay, then it's a new type of intellectual property called as domain name. Domain name is a website address. Now every company has a website address, every institute has a website address. So every startup also will have one or multiple websites, and their website address should be sensible and related to their marks, so that from website you can very easily identify what this company is. There are, see, for all other forms of intellectual property, that is patent, design, copyright, or trademark, these are registered with government office, and government has regulations on that. Government gives protection, saying that you register with us, you disclose it, and in turn government will give you protection that no one else can copy it. For domain name, it is open, anyone can register any name. So for startup, you have to be very careful selecting a name. Also be careful that you should not be close to someone else, using someone else's name there. And last is trade secret. So trade secret is something very confidential information which you don't want to disclose. If you file a patent, patent is published, everyone knows what is written in patent, but they cannot copy. Trade secret is exactly opposite, that you don't disclose anything what you are doing. And then government does not give any protection on that. You have to protect it yourself. Keep it secret yourself. So Trade secret can be for hotels, it can be a recipe, or restaurant, it can be a recipe. For engineering companies, it can be a manufacturing process. For pharma, it can be some specific composition or chemical process. Or for sales team, it can be a specific pricing strategy. All this can be sales trade secrets, kept internally secret. No one else knows that except few people. So all these are forms of intellectual property. They provide different kinds of protection to the startup, the basic idea, and the business that you are creating. Now, when we expect someone else should not copy my idea, I need to protect my idea from copying or infringement by others. Same time, we have to take care that we also don't copy someone else's idea. We also don't infringe on someone else's intellectual property. And that's why this awareness is important. Okay. So any question, any doubt on this part?
No, sir.
Yeah. So I expect at least one question. Without that, I will not move on next slide. So,
Can I ask one question?
yes, sure. Please go ahead.
For this logo or brand name or company identical sign, does it has to be renewed frequently, or once it is been registered, it is permanently accepted?
No, these require regular renewals. All these rights require renewals. Patent requires every year it needs to be renewed, and it can be valid maximum to 20 years. So you can renew up to maximum 20 years. After that, it won't get renewed. Design registration is valid for 10 years. Maximum you can renew 4 more years. Copyright once registered is valid for 60 years. So very, very long period. A trademark needs to be renewed after every 10 years. So there are regular renewals required. Domain name, you have to pay its registration renewal fee every year. Trade secret, obviously, you have not registered anywhere, so you have to keep it internally secret. But for every kind of this right, regular renewals are required.
One more swap question.
Yes.
Suppose somebody forgets to renew it in a stipulated time, and that stipulated time is over for renewation, and somebody else opt for that. Is it allowed for that the next person to get that this one brand name or logo?
See, it is a generic question. So I will give generic answer that it depends kind of thing. If it is a patent, it has expired, anyone can use it. If it is a trademark, there are stipulated renewal times given. Even if it is not renewed, someone else may start using, but they may not be able to register it again.
Okay. Because there was a fight between Coca-Cola and Pepsi for Dil Mange More, that slogan was registered, and there was a huge legal battle on that.
Yeah, correct. So that's where I said it depends case to case, that is that slogan still or any mark still used? Have people forgotten that? Are you spending on that? Is other company already started using? So a lot of things are dependent on that. So whenever we say we own the IP, we have to actually keep using it.
What is the stipulated time to renew it?
Yeah, so renewal will be there. Renewal is on paper, but your rights are alive only if you are actively using it. Okay, all these rights are given by government, provided that they actually help business and economy to grow. That's the ultimate thumb rule applied by any court. So if you are not using it, you are not helping economy to grow, you may lose that right.
Okay.
So along with regular renewal, regular use is also expected. So any other question?
Okay, got it.
Yeah. Any other question on this?
No, sir.
Please ask one more question. Dil mange more. Like he said, dil mange more. One more question.
Okay. Sir, I had a question.
Yes.
Is there a limit on the patents that you could take as a part of an organization, assuming Tata Motors for Nano? So they
So I'm not
cap
clear.
on it, or
Limit
they
is
can,
what?
like, suppose they innovate another design. So, and they keep innovating. So they have created maybe 100 designs.
Yes.
And they would want to go. So is there a cap on it, or there is no cap on the total number of
So there is no
patents
cap
that
on
you
it.
could take?
Okay, there is no cap on it. You can file as many patents as you want. In fact, one product will have multiple patents. Like you see this Tata Nano picture. Okay, it may have, I believe it has at least 40 patents in it on different technologies.
Okay.
If you have a mobile in your hand, it has at least 50 patents, one on screen, one on microphone, one on camera, one on the chip inside, one on some communication device, one on Wi-Fi. So every equipment you can see, there will be multiple patents on that. Plus, as you said, if there is one product and can you create many patents? Yes, you can create multiple patents to create a strong patent portfolio so that someone else cannot copy your ideas or copy your product or even copy possible variations of that.
Okay.
So that is possible.
Okay. Okay. Thank you, sir.
So now moving ahead, I will just touch upon more on patent side because patent is most spoken about, and patent provide very strong protection and very strong valuation also for any startup. So when we speak about patent, what is a patent? So I believe you can see a very nice bungalow over here. And there is a reason why I'm showing that. Because when we say patent, it is form of intellectual property. IP is intellectual property. And in intellectual property, most important thing is property. Okay. So I believe whenever we speak about property, all of you maybe started imagining property as a house, bungalow, a land kind of thing, which we call as a real estate. And coincidentally, patent is actually like this real estate. Okay. Very, very similar. Like you can build a bungalow, you can own it, you can rent it, you can transfer it, you can sell it. Same way, you can create a patent, you can own it, you can transfer it, you can sell it, you can license it. It is just like a real estate. All these transactions can happen because it is a property. Only thing, the bungalow is a real estate, it is a tangible asset. When we speak about patent, it is an intangible asset. You cannot touch it. But it provides all the benefits of property and it has all the properties of actual property or actual asset. Okay. So patent offers very, very high valuation if you have a patent on your name or on your startup's name. Now it is a part of skill that if you solve a problem, how you can fit it in a technical solution and get a patent on that. So what is a patent? So patent looks like the certificate I have shown on the right hand side. It is an Indian patent certificate you can get if you register for an good idea. So it is as I said, it is a property right. It is an intangible asset called as intellectual property that is created by our mind, created by our thoughts, and provided for technological advancements. So it can be a minor modification also. Important thing is to get a patent, you need not have a breakthrough innovation or a great big product. Even a modification in existing product can be patented. You can get a patent for that. A small modification, which is a technical advancement, which improves the performance, can also be patented. So need not be a actually breakthrough, and that's the misconception of people, that you need to invent something great out of the world to get a patent. No, simple thing can also get patent. I have already got more than 1200 patents for inventors from the organization where I work. So I myself have more than 10 patents filed. So it is not a great thing. Anyone can do it. Just come up with a good idea. So as I said, patents are of two types. In engineering patent, there is third type called as a plant patent for biotechnology, which I am not expert in. So engineering patents are utility patent and design patents. So utility patents are for technology advancement. They refer the functioning of patent, how patent works, how technology works, and valid for 20 years. And Indian patents are valid only in India. If you want to have protection in US, if you want to do business in US, you have to file separate patent in same patent in US, you have to file again. If you want to continue business in China, same thing, you have to file patent in China also. So individually they need to be filed. There is nothing like a worldwide patent. That is absolute misnomer. And then second is design patent, which is only for aesthetic appearance. I believe you can very easily identify which bottle is this. Which is this bottle? Can anyone tell?
Coca-Cola.
Yes. Can you a bit louder? I was not able to hear.
Coca-Cola.
Yes, correct. It's a Coca-Cola bottle. Okay, without Coca-Cola written on that or without any liquid shown in that, you can still identify because of its unique shape. So something like that can be design patent, which is non-functional. And still you can have protection on that, and that is for period of 10 years. Now from startup point, very important thing is, if you file utility patent, generally it takes around 2 years to 3 years to get that patent granted on a normal track. Design patents you can get in 6 months. Because for utility patent, patent office conducts a very detailed study, examination, that if someone else in world anywhere has done something similar idea, and they take a long time to check. Design registration is not for technology, it is only for looks. So checking it is very quick, and you get this design patent in 6 months. So when you think of a startup and its IP portfolio, design patents can be a good addition to that if you are working on the real products. Also, Government of India has a scheme under Startup India, under which you can get very good discount on filing patent, on the fees for filing patents, and also you can go for a fast track or tatkal kind of a patent grant system. So under that, within max 1 to 1.5 years, you get a patent granted in your name, a utility patent, which otherwise will take at least 3.5 years to get granted. So all these schemes are there, and I believe under that, to promote these schemes, government is supporting institute like yours to conduct the training sessions, set up the startup incubation centers, and then provide IP support for that. So take benefit of all these things. So patents I will not go in detail, but to get a patent, you need to have an idea which is new, useful, and it should not be a very minor change. Okay, obvious thing anyone can do kind of thing. It should be at least a small step change. Step need not be a very great, but at least understandable separate step should be there, what we call inventive step. So must be a practical thing, a novel thing, and should not be a minor change. Now these are all legal terminologies. I put a simple thumb rule that any technology that reduces cost or improve performance can be patented if it is something new. And thumb rule is, we don't want a competitor to copy. So if you show this idea, will other few people ready to copy it, or will they like to copy it? If yes, it is definitely a patentable thing. You can file patent on that. If nobody is interested in copying your idea, then it is of not much use to get a patent, because it may not be much relevant for other people. Okay. So as we are going to have a separate session on patent, I am not going in the detailed process, but a simple one. Idea to patent journey starts with identifying a problem. As I showed you initially, that mere paas maa hai. So necessity is the mother of innovation. You should have some necessity, some daunting problem that you want to solve, and then you get an idea, you record it on paper called as invention, you describe that invention, then external attorney can help you to draft a patent, which then needs to be, that application can be filed in patent office publishes it after 18 months, then it goes for examination, and then patent is granted. This entire journey, top line is within your institute, within your organization, and bottom line is within patent office. So a lot of things can be patentable. Anything new, technical thing, anything new you do can be patentable. Even computer programs are patentable, provided they have a new algorithm and they generate they interact with physical system. The outer world, they should interact, definitely they are patentable. So anything you come up with solutions to solve a problem can be protected with patents. Now, how to get new ideas? It's the next thing for startups, that you want to solve problem, but how to find these solutions. So most important and easiest way is copy the ideas. Now, copying is considered very bad in academics. While you are writing your exam papers, you are not supposed to copy. That is good thing. But when you are working in actual business, in corporate, or creating your startup, copying can be much easy, because someone else has invented the wheel. You don't need to reinvent it. You can think how to improve on that wheel. So copy the wheel and make addition of improvement in that. So in academics, when text is copied, it is called as plagiarism. When you want to publish a paper in journal, this plagiarism is to be strictly avoided. Okay, but that is only text. If you copy the ideas in that text, that is called as inspiration. That is allowed everywhere, because you can get that idea and make it in your own way. So general simple example I give is, if you see any movie, okay, from ancient time, there used to be a very standard storyline, Ek Phul Do Mali. Okay, that was a old age Hindi movie, probably when my parents were young. But then that storyline still continues. Idea is same. The expression idea, the way of presentation changes, and probably on same theme, there are more than 100 movies. Okay, so it is inspiration. You create your own one out of that. So don't be afraid of copying the ideas. You copy it, but with adoption. If you see good idea, understand that, adapt it, and apply it to make your own business. Okay? It is not a sin to copy ideas, but don't, when you are doing it, you have to be aware of IP. Anyway, I will touch it in next slide. Simplest thing of getting new idea is copy others' idea. But for that, you have to keep observing. You have to be vigilant. You have to see around. Someone said sometime in chat box that innovation can happen accidentally also. So innovation never happen accidentally. Someone is very vigilant. Someone is keep looking for solution, and all of a sudden something comes in front, and that person can identify, yes, this is the solution, because that person's mind was working on that. And then that person can adapt that idea to the solving problem. So same thing, you can do it. I'm just putting a cartoon here that idea is same, but expression of idea is different for everyone. You may say that they are copying each other, but everyone is creating a different painting. That's how it happens in the startup world also. You may have Swiggy also, you may have Zomato also. You may have Ola also, you may have Uber also. But everyone has a different business model. Everyone has a different way of execution, providing same service. Now coming to the last part of why IP is required for startups. We are seeing today's session, what are different forms of IP, especially if you need a patent, what kind of thing can be patented, and strong protections can be achieved. So why IP is required? Like when you say startup, what you require is an idea, you require capital, you need resources, but along with that, a strong IP is required. Right? Most important thing is to improve valuation. Most of people create startup because over a period they expect someone may acquire it, or its valuation will increase, they will sell some part of it, get a lot of money. But that is possible only when startup has good valuation, and valuation increases if you have IP on your name, because then you can stop competitors from entering in that business. So first is valuation. IP drastically improves the valuation. So if you are thinking of any startup ecosystem, first think of IP. Second, entry barrier for competitors, that if you have IP, you can stop competitors from entering exact business, or in fact, in some regions, you can stop them, or in some product lines, you can stop them. IP barriers are very, very strong barriers for business. And in that, trademarks work very strongly, because if you have registered a mark, if you are using the mark, no one else can use similar name for similar products or services. So many companies have faced very strong issues on that. So you should be very clear of that. So it creates an entry barrier also. And if a big company is trying to block you, it helps you in defending the business. That many startups or small companies may not have IP and may very easily get caught in legal troubles. If you have some IP, you can also respond to some big companies trying to stop you, or competitor trying to eat up your market. Fourth is licensing revenue opportunity. It may happen that you created a great IP, but you are not using it. Like sometime back, madam said, if we can create 100 patents on one product, 100 variation. Yes, you can create that. If you are using only 10 patents and 90 are lying idle, you can license them out to some other companies. You can license them to competitors also. If they are not in creating exactly same products, or you can license it to other companies. In fact, it is a good opportunity for academic institute also to generate IP and license it to industry. Startups definitely can do that. So that is an additional revenue stream. And last is mitigating IP risk, because when you are in business, there will be always IP risk. You may come close to a patent or trademark of someone else and they may object you. So unless you have your own IP, you may not be able to face them. So it is a kind of a shield against external IP attacks, that if you own IP, you can face others also. If you don't own any IP, your situation is very, very vulnerable in market. So that's why IP is very important for any kind of business. So we just saw why IP is required for these businesses or how it can help. And then, as I said earlier also, when we want, others should not copy our IP or other, we can stop competitors from copying our technology, our product, our IP. We have to be very sure that we don't copy someone else's technology, we don't copy someone else's or infringe someone else's trademarks or patents. So there are always IP risk on the startups, and these risks are very small when it is still in very early stage startups, because no one cares about a small startup. Once they start generating money, people take it seriously, and any IP suits, any IP risk may come later on in the next phases when you start making money using that IP. So first is patents, that it is a technology risk that you are knowingly or unknowingly coming closer to someone else's technology, which is patented technology. So you have to be very careful on that. Second is product, that is design, how product looks externally. If you are designing a product, you have to make sure that it is not something which is protected by design. Someone else's product does not look exactly same. Then it is brand, about trademark, that if you are designing a new trademark, if you are using any new name or designing a logo for that, it should be distinct. It should not be something close to your competitors in the field. It should not cause confusion to end customer. Next is domain name. Domain name is one of the big risks, because someone else can use your company name and register a domain name or look-alike domain name. Okay, like because there is no restriction by government on registration of domain name. If you have, say, coca-cola.com, maybe a website, someone may register coca-colaindia.in or coca-cola.in or cokeindia.in, cokeindia.com. All these infinite combinations are there. So you have to be careful while registering your name, plus be vigilant if someone is misusing your name and trying to misguide your customers. And last is website. Using domain name, finally you may host website, and all the contents on website are automatically copyrighted. One important thing you have to take care that don't copy paste from someone else's website. Otherwise, you are already infringing copyright of that website. So for website also, all these copyright risks are there. Using images, text, you have to be original there. So all these risks are there. If you take care of this risk, stay away from that. Definitely, this IP is very, very beneficial for improving the valuation of your startup, your ideas, and get great benefits out of that. So last slide is, you take care of IP risk, stay away from that by understanding what is IP. And the simplest thing is, keep picking good ideas. If you see a good idea around, uthale. What is uthale? Pick up that good idea. So you have to make a balance between copying the idea and avoiding any IP infringement there. If you can do that, you can increase your business many folds. Your startup will be very, very successful. So keep this mantra, Utha le Baba, whenever you see good idea, try to pick it, adapt it, and avoid IP risk. So I think that's all from my side. We have 10 minutes for interaction. So I will keep it open. All you can post your questions in chat box, or you can unmute and ask your questions. So that's from my side. Any questions? It's open.
I have one question. You said that one has to register his patent in every country differently.
From my side. Yes.
So for that, is there a single window to do it? Because it will be a very time-consuming activity to get it registered, that his patent in every country.
Yes, there is a single window system called as PCT that you can.
One has to register his patent in every country differently.
Can you please mute? Can you please, everyone can you please mute?
So, is there a single?
Yeah, so there is a single window system called as Patent Cooperation Treaty, PCT. You can file in multiple countries at once, but it is only entry is simple. Okay, after that, in every country you have to process it independently. So only entry part is there, but again you have to pay separate fees in every country. You get certificate in every country separately, and you have to do renewal in every country separately. You have to pay renewals every year separately. There is no single window system there after you file the application. So it depends on the business interest. If you have business interest in many countries, you can follow that single window process for filing. Else you can file individually also.
Okay.
Yes. Any other questions? So I'm waiting for your questions. Please put your questions either in chat box or just unmute and ask your questions. I'm waiting for your questions. Please put your. You can put it in chat box also if you have any questions.
Good afternoon, sir. I wanted to ask a question.
Yes.
Sir, can our students take provisional patents for maybe a process improvement or anything which is related to, especially since it's a part of the academic curriculum?
See, you can file it, but strictly speaking, provisional patents will have no value.
Okay.
Okay, because provisional patent is provisional means temporary. You make a temporary application, and then you are within 1 year you are supposed to file a complete application out of that. Else, this provisional application lapses. You never get a patent, or you don't get any right out of that.
Okay,
and
so
it never gets published also. So your students will not get credit for that.
Okay, so you mean to say if we apply for a provisional patent, it works for 1 year. However, if we apply for the entire patent process, so that could anywhere take between 3 years, so that when he actually rolls out the startup and the traction begins, that's when, it's going to make sense. Is that what you're trying to say, sir?
Yes, sure. So provisional
Okay.
is temporary just to get you breathing period and collect money for filing a complete patent, or make sure that yes, this idea is patentable and I should pursue it further. So
All
it
right.
gives 1 year time for that. After 1 year, you may decide that no, I don't want to continue it, or yes, I want to pursue it and I will continue. So both ways are possible. So provisional gives one just additional step uh, for possible protection. But unless you convert it to complete patent, it will be of no value.
Okay. Okay. Thank you so much, sir. Thank you for answering this.
Because finally patents are required for creating valuation for organization, any startup. So for that, always complete patent will have value, or
Okay.
complete application. Yes.
Anybody has any questions? You can type it in the chat box.
Okay. So we'll wait for 1 minute. If someone has question, you can unmute, ask, or type it in chat box. Else we'll conclude the session.
On behalf of students, I would like to ask, can we patent our ideas where we feel that those ideas could possibly make sense, maybe not now, in due course of time?
Yes. So futuristic idea you want to say, correct? Something.
Yes.
Yes, you can file patent on futuristic ideas also, because it may not make sense today, but 5 years down the line, it can be definitely a workable thing. Like you can see drones today everywhere. 10 years back, if someone would have said this thing about drone, people would have laughed on it. Okay, so any good idea, you can definitely protect it with IP, different forms of IP. A patent is definitely one of the strongest of that, and you can file patent. Patent office definitely takes some time to check, but if it is a technically feasible thing, they do grant patent. And you don't have to produce a prototype and prove that if it works. Someone has to just understand on paper it is a technically feasible one. That is sufficient. You don't need to create actual prototype of that. So futuristic ideas can be very easily protected.
So then how would, maybe he takes a patent, and then suppose if some company has really come out with that kind of a product. So is there any commercial value that he could get for the patent which he has got?
Yes, very good question, madam. Because that is the concept of startups. Like you create valuation through patent. And as I showed earlier, one opportunity for startups is to license their IP. If you get any form of IP, it can be patent or it can be a strong trademark also. It can be licensed to other established businesses who want to explore in that business, or who are actual existing players in that business. So someone who creates that kind of IP can definitely get licensing fees or royalties out of that.
Okay.
That is possible.
So these licensing, what you say, for businesses that work, so that would be working separately for separate products. It could be, softwares, it would be different fees. So where is it that we would get an idea of these licensing charges that would possibly come?
Yeah, see, there is a standard thumb rule for that. No company discloses it, okay, because these agreements are nowhere published. But thumb rule is about 5% of sales 2 to 5% of sale. That's the range which is charged as a licensing fee.
Okay.
It
So
depends
we
on
have,
business to business, how much profit that business is making. But
okay.
2 to 5% is a thumb rule.
And we need to approach the companies and tell them that this is the license that you have, that we have, and you're into this business. Is that it works something like that? So how does the procedure really work? And where would we get details about this?
Okay, the process may be different as per the different companies and the product or service you are offering. So many
Yes, sir.
companies have a product management team, and if you are able to approach them, they will take it up. Or means it depends on the company and the product that you are offering. There are different ways. It can be an amicable one, or it can be a coercive one that's saying that I have a patent and you are copying, now you pay me, else I will put case on that. Even that kind of thing may work.
Okay, okay.
And that's where I said it depends on the company, which is the company. As per companies, if company has deep pocket, we will definitely go more amicably. If it is a small company, we may put more force on that to extract money. So all these things, once you are in that startup ecosystem, people will understand
that will be
more
a
how to
real
make
good
money.
input, sir. Thank you so much.
Yes. Then I have a question in chat box. How much it costs for entire processing of patent filing? If you can do it under Startup India scheme,
absolutely. Thank you so much, sir.
Yeah, it is much low. Maybe maximum 16,000 rupees you can get a patent file under Startup India. If you are not registering a startup but independently doing it, the attorney fees may be slightly higher. For academic institute and startup, very special discounts are offered by government patent office, so you can take benefit of that. So with that, we can take a pause now.
Yes, sir. So thank you so much, sir, for making this session informative and so interactive.
Yeah, thank you so much, sir.
And now I would like to request convener of EDSI cell, Dr. Shilpa Kankunkar ma'am, to propose the vote of thanks.
Yeah, thank you so much, Pratik. And at the onset, let me take this opportunity to thank Mr. Nilesh Putambikar, sir, for having spared his valuable time. And he's been so patient with all the questions and the interactions. And really, sir, we are grateful for your, concurrence, for being a part of the Impact Lecture series that we are organizing. Sir, just to tell you that we are a nodal center for Kapila as well. So if anybody wants to actually, especially for the student fraternity, we keep, trying to press upon this point that, yes, we need to innovate. We need to think about areas where they think that can be value add in line with their academics. And this is what we're trying to, put in and, kind of get in through these outreach programs. And of course, sir, this program wouldn't have gone without the support of our director, Dr. Anand Dadas, who has been, very supportive with respect to the activities that we conduct. And we've been very actively involved in trying to outreach these students with their thoughts on innovation and intellectual property. So thank you so much, sir. And I would also like to give a small, there's a feedback link that will be has been put in the official group for Impact Lecture WhatsApp group. So kindly fill it. And with respect to the certificate, there will be a test that will be, put across, which will happen on tomorrow. And then the certificates will be distributed. And do keep attending the sessions. Now we have Mr. Vijay Shivpuje, sir. I think he has also already joined us for the next session. Thank you so much. And thank you, sir, for sparing your valuable time and being here.
Thank you so much, ma'am.
Thank you for providing me this opportunity to interact with all your students. Thanks a lot.
Yes. Thank you
so much,
thank
sir.
you. So sir, we would request all the participants to kindly, switch on their cameras so that we have both the speakers here. So we will take this privilege of taking a screenshot. Pratik, I would request you also to take a screenshot along with Shreyas to take a screenshot.
Yes,
of
ma'am.
this. So this is for documentation process, so we require it. Is it done?
Okay, ma'am.
Yeah, thank you so much. Thank you so much, sir, for sparing your time. We'll be in touch with you, sir. We have certain more engagements that we would really want your assistance and guidance. So thank you so much for your time. Over to you, Prateek.
Yes, ma'am. Thank you, ma'am, and thank you so much, sir. So in continuation with the program, now I would like to welcome Mr. Vijay Kumar Shivpuje, sir.
Yes. Sir, can you hear us?
Yeah, good afternoon, everyone.
Okay. Yeah, continue,
yes.
Prateek.
Yes, sir. So Mr. Vijay Kumar Shivpuje, sir, has completed M.Pharmacy and also holds LLB degree. He has 17 years of experience in pharma companies, law firm, and consultants. Sir is mentor with Startup India, Ministry of Commerce and Industry, and also mentor of change with Government of India's Niti Aayog, Atal Tinkering Labs. He has conducted 100 plus IPR awareness programs at various universities, colleges, bar associations, incubation center, custom office, industry chambers, MSMEs. He is also registered patent agent of India Patent Office. Sir is co-founder of Pharma Literary, an online education initiative which is working actively in area of pharmaceutical education and have collaborated with various institutions and universities for skill-based activities. He is also awarded by the Associated Chambers of Commerce and Industry of India for outstanding contribution in IPR awareness in 2021. Sir is currently director of Patlex Business Solution, a knowledge process outsourcing firm practicing in patents and designs. So now I would like to request our honorable guest, Mr. Vijay Kumar Shivpuje, sir, to take over and give us some of his insightful thoughts about this topic. Over to you, sir.
Thank you. Thank you so much, Mr. Prateek. Just to confirm if I'm clearly audible.
Yes, sir. Yes, sir.
Yeah, thank you. So a very good afternoon to everyone. I'm privileged to be here for the Modern Education Society's Wadia Institute of Management Studies and Research, the Impact Lecture Series under the IIC. I'm very much thankful to the Institute, IIC, and the organizers, convener, and the director for providing me this opportunity to be here and present about intellectual property rights, IPR for business success. So we already had a head start, I believe, with Mr. Nilesh speaking about IPR awareness for successful startups. He must have provided some idea about the broader concept of intellectual property rights and maybe some types of intellectual property rights. Is that correct?
Yes.
Yeah, maybe some slides, or I would say some concepts may be overlapping, because when we think of intellectual property rights, it is something very common to most of the industry sectors as such. Since we have most of the students and faculties that are looking for that have participated for this particular session, let us also try to make it a bit interactive as such if possible. Last 2 years have been something which has been, I would say, really instrumental in terms of the innovation and entrepreneurship ecosystem as far as the Indian context is concerned. There have been two big events, I would say, or two big things that have disrupted the entire innovation ecosystem within India. The first one, of course, I'll refer to the COVID one because I come from the life sciences industry, and COVID has kind of disrupted I would say every industry, including the startup ecosystem or the business ecosystem, or even I would say the education ecosystem as well. किसने सोचा था कि जो हमारे टीचर्स 40 साल से हमें ब्लैक बोर्ड एंड चौक लेके पढ़ा रहे हैं, चौक से, लाइक दे आर यूजिंग दोज ट्रेडिशनल वेज, एंड वन फाइन डे all of a sudden, because of lockdown, we would tell them to use these technology, basically like something like Zoom, Google Meet, or any platform, and then they have to start teaching. Actually, the entire world was sitting at home, but then I would say the teachers or the education system was still working as a, like so we were still studying during that time as well. Now, when we think of innovation or innovation ecosystem, it is something which has got a lot of misconceptions. Basically, innovation may not be a radical innovation. Innovation may be simple improvements and solving the problems that we face day in day out. And we saw this during COVID time. We had different kind of problems actually, and lot of students, as well as I would say the academicians during that point of time, came up with different kind of solutions for those problems, which were, I would say, genuine and very different during that COVID time as such. So that required kind of a different mindset altogether, to think creatively, to think innovatively as well. And this was one event, I would say, that changed the mindset of students, that changed the mindset of the entire business community as well. That we have to innovate, we have to adapt as well to the newer condition, so that the businesses don't get impacted because of the uncertainties we are into. And the second thing, or I would say the second factor that changed the entire entrepreneurship ecosystem in last year, rather not last 2 years, is the way the entrepreneurship was spoken in every household through the simple one, I would say, the kind of entertainment program we had, the Shark Tank India. Actually, Shark Tank India actually provided an insight of the entire startup and business ecosystem to everyone as such. During that time, that has actually helped those terminologies which were used in the business or startup ecosystem are now known everywhere. मेरी 10 साल की 11 साल की बेटी भी अभी she awaits for the next episode of Shark Tank India. She can very easily recognize the sharks. She speaks in the language of sharks as well, and at times she mimics them as well. Now, what has this done actually as far as the business or entrepreneurship or the startup ecosystem is concerned? Now the startup or the innovation ecosystem are not the buzzwords, but they are the ones which are there everywhere all across India. During that time, we also saw that the innovation or startup is not restricted to the big metros, or I would say, or it is not just restricted to the big institutions as well. Rather, many times we saw that a lot of innovations, a lot of startups are coming from second, third tier institutes or third tier cities as well, जिनका नाम हमने कभी नहीं सुना है, वहां से ये innovation हो रहा है. And this has helped the entire, I would say, the business ecosystem for sure, or the startup ecosystem for sure. It has got a really long-term impact as well. And these two things have also helped generally about, I would say, more about the awareness about the intellectual property rights as well. Because what also happened during the Shark Tank India episodes is when there is someone pitching there and asking about some kind of funding for the startup, or providing some kind of stake while pitching, the startup founder or co-founder is also mentioning about, yes sir, हमने इसके लिए patent file किया है, we have got a design file for this. Now, these terms maybe when I started my career 10 to 15 years back, that point of time maybe were restricted to few corporates or maybe only the premium institutions in India. But now these terms everyone knows, and I think that is one of the intents of IIC or AICT as well, that through the Impact Lecture Series we have got awareness about intellectual property rights. IPR is a very interesting, I would say, concept which involves a lot of things which are very essential, not only for the business but also for our routine life as well. IPR, generally, like, we think of IPR, intellectual property rights, when we hear of patents basically, but IPR is a very, I would say, broader term. Every aspect of our life actually is something which has IPR, intellectual property rights, connected to it actually. But then, as I said, patent is a buzzword. Patent sabko pata hai. We speak always about patents, but it's just not about patents. We have a lot of types of IPR, and these are very essential for your business success as well. I'll be going through all these details in my presentation, and also important herein for all of us to understand is that the significance of IPR is not only restricted to the startup ecosystem, but the so-called big companies or businesses as well. They are already protecting their inventions, or they are already using IP as an asset basically. There were some questions actually. When I joined around, I would say 4:15. There were a few questions that were discussed. I just would want to add a few things about those questions that were asked for the previous session actually. So when we think of any kind of protection of an invention, there was a question about this provisional application basically. This is a term wherein we generally call it as I would say advance booking your invention basically. As in, you have an idea, you feel it is commercializable, it has an impact, it is innovative, file a patent. But then it needs to be converted into the complete application as such. Then only it has got certain value. Otherwise, that during 1 year period, you have booked your invention for patent, but then it won't get granted until and unless you file a complete application. There was this interesting question about licensing. And this is one area wherein all the business professionals are pretty much interested into the valuation, the value of IP, the licensing value as well, right? Let me give you a couple of examples actually, which would give us more clarity, or I can get connected to every one of you. How does the licensing actually work? So many of us would have seen this movie 3 Idiots. Yes, have you seen the movie 3 Idiots? Just put it in the chat box, yes, or just put a thumbs up actually. If you have seen the movie 3 Idiots, the movie by Amir Khan, and wherein we had these characters. Yes, I can see Suvarna has seen this movie. So there is this one character played by Amir Khan, as the name is Funsuk Wangdo actually, and he has got a lot of patents in his name. Funsuk Wangdo has got a lot of patents in his name. Now, Funsuk Wangdo is an academician, he's a scientist, he has got a lot of inventions in his name. And then there is another character played by with the name of Chatur Ramlingam. Now Chatur Ramlingam comes from all the way to get license of the patent basically. Now this situation actually gives us a more insight about how licensing works. So if you have got a great invention, or if you have got an invention which has a commercial value, then you don't need to run after the people. If your invention has a good value, then people would come to you, because as you file a patent application or any IP, that would be in the public domain. And once it is in public domain, those who are interested in that invention for sure would come to you and seek a license for that. Actually, that is possible. That is possible, and that's how it actually works. The licensing, it is not the push basically from the patentee. But then when does this happen actually? The invention, getting a patent or in getting any IP doesn't have any value. Why am I saying so? Actually, it would have value only if जो आपका invention है, the one which you have protected, it has, that invention can be marketed basically, and it can be commercialized. If it cannot be commercialized, if it cannot be marketed, there is no value coming out of it, because at the end of the day, no one is going to give you money just because you have got a patent for that or a IP protection for that actually. Now, if you have what I would say a good IP attorney, you can get your invention very easily protected through some form, maybe patent, trademark, copyright, or design as such. But what is important, as I said, if you have got a patent, or design, let's say, and that is giving protection for an invention जो कि commercializable है, in that case only there would be licensing happening. If I have got a patent for a product which is not at all commercializable, I may not get a value out of it. I may not get a license value out of it as well. So that's how the I would say the licensing actually works. There is another one example. I can see a lot of people are from Maharashtra. There was this one Marathi movie called De Dhakka, and De Dhakka. So in that there is a character played by Makaranda Naspure. What he does is he has actually innovated and come up with a part of a engine basically, which is used for increasing the fuel efficiency. That's how it is shown. At the end, he loses that part basically because of one of his relatives. At the end of the movie, it is shown that his friend tells him, okay, you don't worry, others can't use your IP or that particular part because we have protected it. We have got an IP protection for it or patent protection for it. Now, IP rights, intellectual property rights, never give you any right to commercialize. IP rights, all kinds of IP rights are, they are also called as negative rights. Means what? If I have an IP, then I can exclude everyone else except me to use that IP. But having an IP doesn't give me any right to commercialize. How does it actually work? When we think of life sciences, or I would say the pharma biotech kind of industry, in that case, getting that IP, getting a patent is very different from getting an approval for the product actually. And for that, you need to conduct the so-called clinical trials and a lot of other things. So IP right, all the types of intellectual property rights are the ones which are negative rights. They don't give you the right to commercialize. Rather, they give you the right to exclude everyone else from using that particular intellectual property. And that's how the IPs are, intellectual property rights are different basically. I'll take you through the basic concept of intellectual property rights with some live examples from different industries. It is very essential for us to understand that the intellectual property rights or the IP rights are different for different industries. That means for an industry which is research based, for them the right kind of IP may be patent, but for some kind of, I would say, for example, for a jewelry designing or fashion designing, the type of IP right may be different actually, and it may be with respect to industrial design. For something like, IP is part of each of our other aspect of our life actually. So for example, at this point of time, we are doing an impact lecture, which is sponsored by MOE, Ministry of Education, which is actually done by Modern Education Society's Neville Wadia Institute of Management Studies and Research. We have got speakers from outside. There is a recording happening for the session, which is also live via YouTube. Now, the key question here is, who owns the right for this entire session? Who owns the copyright for the session? So it is actually the IP is just not restricted to the invention, but almost every part of our life actually is connected to intellectual property rights by one way or other. We'll try to understand these concepts or these things one by one with the different types of intellectual property rights. Let me just share my screen. Can someone please confirm if my screen is visible?
Yes, sir, it is visible.
Yeah, thank you, Pratik. Yeah. So,
Yes, sir.
yeah. So when we think of intellectual property rights, why is it that we are speaking about on one side innovation, which is a more technical thing, which is done by the scientist. We are also speaking about the legal rights for that. And on the third part, we are speaking in front of the B school students as well, or which is more about the business as such. As the name suggests, the intellectual property rights involve three separate things actually. One is the word intellectual, as it shows, it is more of technology, art, or creation. Property, which is more about the business part, and rights, which is more about the legal part basically. Now, when we think of property, generally the kind of properties that we know are the bank balance, the gold, I would say maybe a land, a flat, plot, car. Now, when we think of these as a properties, it has got some values, and these are tangible assets basically, which can be valued directly. But then we have also heard that in last 2 decades, probably 2 or 3 decades, that knowledge itself is a property, knowledge-based economy, that's what we call it as, right? So when you have a knowledge, which may be a technology, it may be an art, it may be a creation, and there is a value associated with, if you can generate business out of that, then we call it as intellectual property. And that is an intangible asset which cannot be valued directly. But now, when we think of intellectual property, like for example, I have got an iPhone. How would I show or tell someone that I own this iPhone basically? What is the proof basically, the legal proof? The day I buy this iPhone, I get a receipt in my name, and that receipt acts as a legal proof that I own this iPhone basically. Similarly, if I have got an idea which is related to business, it may be related to a technology, it may be related to any artistic kind of, I would say, or anything which is with respect to an invention. Koi bhi art hai, painting hai, any book, anything for that sake. And it has got business value out of it. This can be protected by something called as intellectual property rights, the legal rights for your intellectual creativity basically. And when we say intellectual property rights, as I said, the legal proofs are provided by whom? Then we have these different types of IP rights. The rights are given to you by the Indian government, and these are provided by actually the central government of India. So we have the different types of offices as well. We call it the IP office, intellectual property office, under which we have the patent, copyright, trademark, GI, industrial design offices actually. So these are given to you by, just like you have a passport, or just like you have, I would say, an identity, or a driving license, let's say, which is applicable only within the Indian territory. Similarly, you would have the IP, intellectual property right, for your invention, technology, art, creation, which would be restricted to that particular territory only. Means what? For example, I have an invention, then I get a IP for that in India, then my rights, legal rights, are only restricted to the Indian market only. How does it work when we are in an open, I would say, economy? We are globalized now. An Indian company, a Pune-based company, or anywhere for that sake, are selling their product in, let us say, in 100 countries. Then in that case, it is very essential that as an organization, you are protecting your invention in all those 100 countries. That is important, and there are different ways out for actually doing that actually. So when we think of the any kind of business, there are two separate activities or things which are very essential with respect to intellectual property right. The first important thing, are you creative? Are you innovative? If yes, then protect your invention or protect your creativity. This is the first part. That would block everyone else from using your IP without your permission actually. This is first important part. But the major part or the bigger part with respect to IP is wherein, what if I am an MSME? I am a small startup. I am having small business as such. That point of time, it is very essential that you are not using third-party IP. Not only protecting your own IP, but respecting the third-party intellectual property rights. किसी और का rights आपको copy नहीं करना है. That is called as infringement of intellectual property rights. And let me tell you lot of examples actually with respect to various industries actually jahan pe infringement is something that happens. For example, generally we don't understand this, but when we download a movie from a torrent or website actually, now it's very less actually, but maybe a 10 or 15 years back, कोई movie release होने से पहले दिन या एक दो दिन पहले ही किसी website पे available होती थी actually. Now they are using technology at its best to avoid these kind of scenarios, but still, when we download that movie, how is it impacting the business basically? So downloading a movie from torrent website is illegal. It is an infringement of the right of someone who has actually got the copyright for that particular movie as well. But then, most of the students, maybe we are not knowing this, that it is an illegal activity actually. That point of time, it is considered as an infringement action. So all these activities, making copies of the products basically, which you don't own basically, those kind of activities. The second part, as I mentioned, respecting the third party intellectual property rights. That means I am not creative, I am not innovative, but I have to respect the third party. किसी और का जो IP है, I am not allowed to legally use it. And it is my duty. One important aspect is ethical duty, moral duty, not to use that, not to copy that. But beyond that, it is the legal duty as well to ensure that we are not using the third party rights as such. This is very crucial. This is so if you are in business, if you so the very first thing, I'm also into I would say I'm in business now since last 5 years. I am into the service sector actually. The one thing that every businessman or entrepreneur or startup founder or co-founder wants is a more of clarity of the future and less of legal hurdles. So you ensure whatever you are doing during those activities, you are not using third-party IP, or else you may get involved into some kind of litigation, or I would say some kind of legal trouble or legal hurdles as such upfront. And that would be the worst case scenario for your business as such. So two sides. One is protecting your inventions or protecting your intellectual creativity if you are innovative enough. Second, if you are doing just another Me Too kind of business as an MSME, as a manufacturer, a shop, anything for that sake, ensuring that you are not using the third-party IP. These are two most essential things as such as far as the businesses are concerned. So for example, if you are looking, if you are like, you know, post your studies, you are moving to a job which is in an industry which is research based. In that case, you need to ensure that you are protecting your inventions as well as, so what are the research based industries generally? The chemicals, the tech sector, the pharmaceuticals, the biotech, the automobile, the telecommunication, electronics. We see so much of inventions or innovations happening in this domain basically. Now, as I said, the intellectual creativity can be anything from the software, the invention, the music, shape, configuration, composition, pattern, color, creativity, distinctiveness. Let me tell you, every industry, be it agriculture to software, every industry has got IP involved into that actually. How? We'll see this through this one particular example. I have set these examples, or I would say these are the creators actually. They are creative people. We have a lot of examples. We have a scientist here, we have a singer here, we have an actor, we have a cricketer, as well as we have a fashion designer. Now, a very simple question. Of course, each one of them is creative in their own area or own sphere as such. Now, when we see these people, they are all creative, but can we compare them? Can we say that a scientist is better than a cricketer? Or can we say a singer is better than a fashion designer? No, they are in their own domain basically. They are there in their own domain. They are excelling in their own domain. They are innovating in their own domain. They have got an intellectual creativity in their own domain basically. What is important here for us to understand is that since we have different types of creativity, IPR, as I discussed, is about protecting those creativities. And if we have different types of creativities, that's the reason we also have different types of intellectual property rights as well. And these intellectual property rights play a role in different types of industries in a very different way. So we have the well-known, or I would say the very famous patent as one of the intellectual property. The other one, which is very common in the movie industry or the website tech industry, technology or the websites or the newspaper, the television channel, news channels, everyone actually. is having this one kind of IP which is very important for them, that is copyright. Patent, as I said, is for research-based industries that I mentioned: chemical, automobile, pharmaceutical, biotech, simple mechanical, like electronics, telecommunication, these kind of, or anything which is into diagnostics. So that kind of industries, for them, the patent is a right kind of IP which is useful for them actually. Another important type of IP is trademark. We'll see some examples of all this. Another important type of intellectual property is trademark. Trademark is something which is applicable for all across the industries. In fact, right now in front of you, there would be so many products which you are using, be it your mobile, be it this dongle that you have, be it the keys, the water bottle, everything, basically, every product, the laptop, the tablet, the iPhone, the iPad you are using for watching this session, everything is actually is something which requires or which has got some role of trademark in it actually. So be it with respect to the name of the product, be it with respect to the logo of the product, be it with respect to the, I would say, the tagline of a product, anything for that sake. That is what a trademark is. We have an interesting kind of IP which is generally not considered as IP as well at times, which is, we don't have a specific legislature for that in India, which is trade secret. Trade secret is something which is very essential when you are dealing with your innovations, when you are collaborating, when you are filing the IP, that point of time as well. Trade secrets are the one which are very useful for your business as such, because trade secret has a lot of value actually, and it is something which has an indefinite value basically coming out of it. And how it works in even during your collaborations or business. So for example, you have got a product which is I would say innovative, and for collaboration you have to discuss the product details with someone else. That point of time, it is very essential that you sign a non-disclosure agreement or confidentiality disclosure agreement with the other party, so that whatever you are disclosing it to others is not shared further or not used by the other person. So for example, I am a patent agent. Every day I get some inventions that come to us for patent filing purpose. When you are disclosing these inventions with a patent agent, that point of time as well, you need to ensure that you have a confidentiality disclosure agreement that is signed with me, so that I am not using your invention, or I am not filing a patent in my own name for that sake, right? So it is very essential, the trade secret, what we call it as actually. The confidential disclosure agreement or non-disclosure agreement ensures that whatever activities or the business secrets that you have are kept as a trade secret. And how does it actually work in the business? Now, when we think of a small organization, and again, let us think of a startup or MSME. We have a lot of vendors, and at times we are getting the I would say the raw material at a specific price which is way lesser compared to others. This information itself may be a trade secret which need not be disclosed. Again, the same thing. As a employee of an organization, if you are joining any organization, that point of time, if you are aware of certain information from that company, it is your moral and ethical duty to ensure that you are not using or disclosing that information further. But beyond that, it need to be bound by a contract as well. So जिस दिन आप किसी ऑर्गेनाइजेशन में ज्वाइन करते हो, that point of time you are getting an employment agreement, and in that employment agreement you would also have a clause for confidentiality disclosure. That means you won't be disclosing the confidential information of that organization to outsiders actually during the employment or once you leave that job as well. These are, as I said, the beyond ethical and moral duties, especially students at young age, they may not know repercussions of these things actually. But let me tell you, the law works in a very different manner. If you are not aware, or if you don't know, that is not an excuse for the law basically. If you don't know and still you unfortunately disclose that information, still you would be liable for whatever I would say the damages or punishment that is there under the law actually, because these are intellectual property rights. When we think of rights, these are actually the legal rights, and that is important thing, and that's the reason you need to ensure that beyond the ethical or moral duty, it is your legal duty not to disclose it with others. So this is all about trade secret. I won't be going into much details of trade secrets at this point of time actually. We have another type of IP, industrial design, which is, I would say, different from patents, and which is very interesting for few industries like the fashion, the jewelry design, the handicrafts, or any kind of articles which are products basically. Okay, and then we have GI, the geographical indication, which is also very significant for has something to do, the quality of the product has something to do with local climate, local soil, or local skill set. In that case, GI is a, I would say, wonderful kind of intellectual property rights as well for them. Now, it is also essential from business perspective. What is the right type of IP for your creativity? In many cases, for one product or one service or one invention, you can have multiple IPs. So you can have a patent for the same, you can have a TM for the name, you can actually have industrial design as well for the same, you can have some kind of trade secret for the same product as well. As well as it is very, I would say, essential for a business to understand the legal ownership of that IP basically. A very simple question that is generally asked is, who owns the patents, who owns the IP rights? For example, during the employment or during your association with an organization, you develop a product, you are an employee of that company actually, and that point of time, the product, of course, it's your intellectual creativity. We are saying intellectual property rights. Who's intellectual? The individual's intellectual actually, right? But in that case, when we think of intellectual property rights, the ownership plays an important role. If you are creating something during the employment of an organization, that point of time, you may be an inventor for that invention, but the legal ownership would always be with the business house or the corporate basically. We also call it as assignment actually in case of patents or trademark or copyright or even design for that sake. Okay, so these are different types of intellectual property rights We'll try to understand various kinds of intellectual property rights with respect to different examples, as well as we'll try to understand what are the industries which are dependent on which kind of IP. The first type of IP that we are going to understand is industrial design. Industrial design recognizes the creation of a new and original feature of a shape, configuration, surface pattern, ornamentation, and composition of lines or colors, which in the finished state appeal to and are judged by the eye only. Means how it looks, the external appearance of the product, the aesthetic looks of the products are the ones which are protected by the industrial design. In a layman language or simple terms, how does a product look like? How does it look like, that external shape, external appearance of the product? And this is very significant in those industries specifically jahan pe the consumers or the end users buy the products, purchase the product based on the external outlook. Simple example, jewelry. Now, when we go to buy jewelry, generally I have this question: this is a gold jewelry, silver or diamond? Why is there is a pricing difference basically? Now that design, kabhi-kabhi ye hota hai that a specific design has got a value as such, and that is something which can be protected under industrial design. Let me tell you, all these big jewelers, the TBZ, Joya Lucas, all these big jewelers, all of them protect the designs of the jewelry through industrial design. This is one example. Other example is the fashion industry. All the clothes, all these so-called the fashion experts, they are protecting their new fashions through the industrial design. We have a lot of examples from Manish Malhotra to Sabyasachi. Everyone is protecting their designs through something called as industrial design. So if you are in that industry, if you have your own business venture in that, if you have a startup in that industry, for sure industrial design is something which is very significant for you. Another wonderful example, for example, when we think of the automobile segment, let us think of the four-wheelers, the cars basically. The shape of a car from the different makes, like be it a Tata, Nissan, Hyundai, Maruti, Mahindra, the shape of a car would be always different from each other. Although many a times the technology may be same, many a times the various parts used in that car may be from the same vendor, but the shapes would never be same for two reasons. One, because the shape of the car as well can be protected under design. It may be protected. Nano, when we think of nano or other kind of examples, they are protected and they are protected. Just a request to mute yourself. I request host to mute the participants, please. Yeah, Prateek.
Yes, sir. Yes, sir.
Just mute Suvarna. Yeah.
Yes, sir. 1 minute, sir.
Yeah, thank you, Prateek. So we were discussing about the shapes of the car, or the, I would say, shapes of the various product as. And herein we have these different examples from the TVS, so we have this tire from e-cycle or bicycle to a bike, which is from Honda Motor. Then we have this one example of from the fashion industry, someone from Surat has protected. We have Huawei Technologies, which is a telecom company, which has protected the, or simply any product like a chair, basically. So the external outlook of the product is protected. How it looks. So the big companies like LG are protecting the shape of refrigerator, or even your relaxo footwear can protect, give you protection for the products that you are actually preparing. It may be like, look at these examples. We have the big MNCs like Huawei or LG. Beyond that, we have the local players from Punjab or New Delhi as well, who are protecting cloth frying stand or bag as well. Look at this. Another example, electric scooter, a jar of a mixer grinder. There are so many examples wherein the shape of the product is protected. Now, how is it important for my business? The value of IP comes from different, I would say, aspects, basically. The first important aspect is, of course, you are excluding everyone else to use that particular IP. That means, for example, if this Honda motor has protected this particular motorcycle design, no one else except Honda motor can use this design for 10 years time, because the timeline limit for design, the tenure term for design is 10 years, which can be extended by 5 years actually. Okay, so this is an example of design. Another important thing which actually works on ground. Firstly, you are using this design, excluding others from using this design. Another important aspect is, many a times, especially the small players, or I would say the MSMEs or startups, if they see that the product is IP protected, then they won't copy it because they don't want to go into legal hurdle actually. This way as well, you can protect, I would say, your business interests, and this works really well for many industries. So for the design, as I said, the fashion industry, the jewelry design industry, so ye kabhi kabhi hota hai, jaise when we go for shopping, that point of time, this happens many a times that mujhe ye design ka shirt pasand hai, but iska color mujhe nahi pasand hai. So I would say, show me a different color in this design. Ye jo design ki baat kar rahe, that is something which we speak of industrial design. Remember that this design is for the products only. It is for the products only. It's not for the painting or any architectural design and all. It has to be a product which can be seen, which is visual, the aesthetic look jise bolte hain. That is the first type of IP. The second type of IP is very interesting, geographical indication. The mainstream media loves this. Basically, they call this as a patent. So they would call Mahabaleshwar strawberry got a patent. Rather, it's a GI, basically, geographical indication. Now, GI is a sign used on goods. So there are certain conditions for geographical indication. First condition is the quality of the product has to do with reputation, or I would say the quality of the product has something to do with place of origin. मतलब एक जगह किसी location का कोई एक चीज famous है. For that, GI is something which is important. Now we have this example actually, which has a lot of GIs from India. We have the Kashmiri Pashmina, Sileke, we have the Tanjavaram paintings actually. Now, if you look at all these products, you would understand that the significance, like for example, in Maharashtra, we have Mahabaleshwar strawberry, we have the Nagpur oranges, we have the Alfonso from Devgarh. So we have a lot of examples like this. Now, As I said, three kind of categories. First, food products. Like for example, the Nasi grapes, the products which are, I would say, the products which are Nagpur oranges, or any food products, basically naturally occurring products. The quality has something to do with local soil or climate. Uska quality specific hota hai and reputation hota hai. Second kind of products, I would say, are more like handicraft, like Surat Zari craft we have, Salem fabric, actually, right? All these kinds of products are which are specific, which are into handicraft. And the third kind of product what we have, I would say, are the ones wherein local skill set. So for example, Kolhapuri chappal, Solapuri chadar, these are some wonderful examples. The local skill set, the MSMEs, the manufacturing units, the local people have certain skill set which gives them, I would say, uniqueness for those products actually. Now, what protects them is geographical indication. But then these are not private rights. These are community rights. When I say community, it is not about the religion, caste, but it is about the region per se. So for example, when we think of Kolhapuri chappal, all the local manufacturers who have got that skill set, they can get GI for that. So these are community rights. It is not the legal right. And one unique thing about GI is the products are not new here. Solapuri chadar or Kolhapuri chappal or Mahabaleshwar strawberry, they are there since ages actually, right? But they are not new, but still there is an IP associated with it. We call it as a community right under the geographical indications. Remember, agriculture product, any product which is from the agriculture, food products, handicraft, or anything which is a local manufacturer skill set, for them you can get these kind of IP rights. And we have the big names as in the very famous, I would say, the Darjeeling tea, as well as the Kashmiri Pashmina are the wonderful examples which are globally known for the quality or the reputation actually for these products. So for these, you can have the GI, the entire local community, group of people. It has to be a group of people. If I am from Latur, I am from Latur, I cannot go and get a GI for a product from Latur. But it would be a local group of people or manufacturers or producers. It may be farmers, it may be the manufacturers, or it may be the associations who can actually go for the legal right protection under GI. Third important type of IP right is copyright. As I discussed, who owns the copyright for this session? Now it is live via YouTube as well, right? Now, when most of you, many of us have got YouTube channels actually, right? Now, if you upload the content from some other channel, you would get a copyright infringement notice. And if there are 3 instances, your channel will be blocked. The original content for that copyright, original work of authorship, copyright is something which is giving you the protection to the author, original author. And it can be, and this is one type of IP which is very significant for the entire education ecosystem. Imagine a situation during COVID time, a faculty has created a lot of videos which are on the YouTube channel during the employment, and the faculty leaves the institute. Now, who owns the copyright for those lectures? Is it the faculty, or is it the institute in which the faculty was working And during the employment, as a part of employment, the videos were created. Now, who owns that? The copyright for that. Or, for example, any novel, poem, painting, drawing, photograph, sculpture, dramatic work, reference work, newspaper, the list is endless. The entire newspaper industry, the entire publishing industry, the entire websites, the tech, the world, www, the World Wide Web website, everything, the movies, the production houses, the television channels, the news channels, everyone needs this kind of IP right. Their creativity is protected under something called as copyright. Copyright is very essential in these kind of industries actually. So copyrights have, and one simple example of copyright is wherein I take a selfie. Now, during the session break, actually, we had taken a photograph, right? We take a selfie, a photo, it itself is an original work of authorship. There is a copyright associated with it. Now this copyright, but who owns it? The one who creates it owns it basically. But then shall we go for a copyright for this picture? You can get a legal right, but when to go for that? If, for example, if I tell you that the picture that you have, the picture or selfie that associated with your selfie, that point of time, your legal ownership really is required for that. And as I said, copyright is something which is, I would say, very important in the creative industries, the publishing, the movie industry, as well as the television industry as such. One good example the youth can very easily connect to is this one particular post. Actually, maybe Priya Warrior earned more money than probably a salary of an employee in his or her entire career. Now, who owns the copyright for this basically? So copyright. So this is one example, like, you know, your selfie, the pictures, the movies, the TikTok videos, and everything can generate a business for you. But what is important for you actually is to ensure that it is a original content. If it is not an original content, you are in trouble. If it is an original content, you have the rights for it. If it is not an original content, probably you are in trouble. Not only trouble, you are in a legal trouble. You would have to bring down that video. Like, you know, I had one friend, I won't call him a friend, he was rather my student, I would say. And he mentioned me that in 3 weeks time, his YouTube channel was monetized. I was surprised because it requires a lot effort to monetize your YouTube channel. So those of you who have YouTube channels can very easily understand it. How much efforts does it take to monetize your YouTube channel? Be it in any industry, be it into education, be it into entertainment, any industry. Within 3 or 4 weeks, he got it monetized actually. But then I said, how much did you earn? Or how did you actually, how is the channel doing now? He told me that my channel is closed now because I didn't know about copyright. I didn't know that I cannot upload someone else's content on my YouTube channel and start earning money out of it. Yes, there is a copyright associated with it. What you can do is check if you have of course, those who are having the YouTube channel, just try to upload a content from third parties, and there would be a copyright check. You would be getting that notice, 3 notices, and your channel is blocked. Right? That's how it actually works. And how is it done? it is actually done through the, I would say, some kind of technology as well as some kind of, I would say, if it is a replica of something else, the YouTube would automatically detect it actually as well. That's about the third type of IP, which is copyright. So we saw three types of IP. First, important design, the GI, the copyright. The fourth important here NS, TM, trademark are written in a circle. So copyright is generally mentioned as C in a circle. So if any content is copyright protected, that means you cannot do that. It's a very gray area. Like, you know, so for example, कोई book है, उसका एक chapter मैं copy कर रहा हूँ, photocopying. Is it considered as a copyright infringement actually? Now let me tell you another, and we had this wonderful case as well happening like this, which had happened like this, जहाँ पे photocopying was considered as an infringement basically. But then what if I take photocopy of a book and start selling it? Definitely it is an infringement. If you're taking a photocopy of some part of the book just for your reading, then it may not be part of the copyright infringement. But if you are taking half of the book or full book photocopied and start selling it at a cheaper price, then probably then you are ending up in a copyright infringement lawsuit for sure. So for all types of IP, just like for example, if I have a land and someone else enroaches it, it is my duty to ensure that I can't wait for police to come and make that land free. No, it is my duty to enforce my rights. Similarly, in case of copyright, trademark, patent, design, GI, if it is my right, I have to enforce it. I have to file a lawsuit against the so-called infringers. जो enroachment बोलते हैं हम in case of land, that we call as infringement in case of the intellectual property rights. Now, the next type of IP that we are seeing is trademark. Trademark shown as R in a circle or TM written over it. So any product that you have right in front of you, that is right in front of you, if it has got R or TM, in that case, you it is protected by trademark actually. So now what is a trademark basically? Trademark is any sign or a symbol for a product. So for example, the moment my daughter, even my 2.5-year-old daughter, who sees this M written, M and I am loving it written, the moment she sees it, she can very easily understand, oh, Papa, see MACD, let's go there. What does MACD? Now, she doesn't know that, maybe she just has seen that symbol. M, she knows only for McDonald's, right? Or that I am loving it only for MACD, jahan pe food, you would get some snacks basically, or some food products basically. Now, the moment you see something, you know what they are selling, you know what they are doing, the business. It is like a business identity for your business. The trademark, that's what we call it as. We have these wonderful examples, the Apple, right? IBM as a full name, right? In terms of the, I would say the alphabets actually, I would say the logo like Olympics, or I would say the tagline like I'm loving it. The moment I see I am loving it, I know it's about MACD. The moment I see IBM, I know it's a tech-based company actually. The moment I see these stripes, the black and blue and IBM written, okay, it's for the IBM company. IBM may have a lot of different interpretations, but the moment I see this logo, I am referring to that company only, right? Now, trademark has a lot of value locally as well. For example, whatever we speak about or think about, there's a brands का जो पैसा देते हैं ना extra, that is what we give it as a I would say trademark licensing fees. I have got let us say we are in a market जहाँ पे there are two shops and we have got two options, both shirts same color, same quality, but one is branded, the other one is not branded. The branded one is definitely priced higher, right? Now that higher pricing may be the so-called trademark licensing fees. जब मुझे ये दिखाना है, this Apple, it's a phone, a Samsung, an Apple, ये जो brand conscious है generation, for them these brands are something which are very significant for your business per se, are protected under the so-called trademark as such. Remember, whichever business you are into, even not only into business, if you are, let us say, into something, now this particular brochure has got 6 different logos: SVKM, AICT, MHRD's Innovation Cell, IIC, and the Institute logo. Every logo can be a trademark, is a trademark rather. Again, trademark need not be registered as well. Trademark, the moment it is created, you get it. But then registration is something, of course, it has to be new. The registration is something which is mandatory in case you want to enforce the rights. For example, someone else uses my logo at that point of time. If I have it registered, then it's easy to enforce my rights. That's how the trademark works. Next, and the last type of IP that I'm going to discuss is patent rights. Patent, I think we have discussed it in detail in the last session. I have only few things to tell you about patents, and as I mentioned about that movie 3 Idiots, as well as the Marathi movie De Dhaka, in both these cases, it is speaking about inventions, innovations, product or process. These are the two things basically. But then remember that it has to have industrial applicability, which we also call it as, it is either meant for the industry, prepared by the industry, or prepared for the industry. In that case only, you would be getting a patent right for that. For example, someone comes up with I get a lot of queries like this. Sir, hamare bacche ne na, they have come up with a mathematical formula. And can we get a patent for that? A theorem basically, can we get a patent for that? No, it is not possible because it doesn't have the industrial applicability. But you come up with the end product based on that mathematical formula. In that case, for sure, you can get a patent out of it actually. But then it is very important, as I said, research-based industries only. So the industries like chemicals, the biotech, the pharmaceuticals, the automobiles, the software. Unfortunately, softwares are not patentable in India. They are protected under copyright in India actually. Like all these inventions can be protected under the so-called patent rights as such. Any invention basically, it has to be with respect to product, and every industry which is into innovation uses patent as one of the I would say important type of IP as a business strategy. To end with, I have this wonderful slide which this one particular product of toothpaste has got all the IP rights. The product itself or process for preparing product can be protected under patent. The design of the tube can be protected under industrial design. The name can be protected under trademark. If there is one ingredient from a specific location which has a specific quality, actually, it can be protected under GI%. Something for sure would be a trade secret in it as well. So this is how for different industries, IP, intellectual property rights actually work. In case of business, it adds a lot of value through lateral revenue, through licensing. You would have a competitive edge. Your brand itself would have some value associated with it. You would have the monopoly rights, and you would minimize the risk for your business through the IP protection asset. So this is what I have, I would say, for all of you. Once again, thank you so much for inviting me here for this wonderful session. Thank you so much for, I would say, patiently listening for more than an hour. I'm struggling a bit with my voice, but then this was really good to have all of you here. I would be happy to answer if there are any questions. Thank you. Over to you, Prateek.
Yes, sir. Yes, sir. So if anyone have any questions, please feel free to ask.
Any questions?
Hello.
Yes, ma'am.
Just wanted to ask, first of all, I would like to thank you, sir, and organizing team for such a wonderful and excellent session delivered by sir. Very, very much thankful for that. My question is regarding, as sir told, regarding the our activities or whatever creativity. During lockdown, whatever had corona COVID situation, just as an hobby, I have done certain paintings, just referred from YouTube, but those are not as it is YouTube. Some of the creativities I have done. So is it possible to make it as a copyright? Just wanted to ask, sir.
Yeah, absolutely. But then remember, ma'am, first important thing is those paintings need to be original creativities. आपने खुद ने बनाया है.
Yes, sir.
First. Second thing, copyright is possible, but why to go for that? That is important question. Because why do you want to protect legally? हम लोग, okay, मैं आपको एक simple example पूछता हूँ. मेरे पास एक पेंसिल है, मेरे पास एक आईफोन है. मैं जब पेंसिल खरीदने जाता हूँ, do I take a receipt for pencil?
No.
But जब आईफोन खरीदने जाता हूँ, तो उसका receipt लेता हूँ ना. There is a value associated with it. That's why I want a legal proof.
Yes.
अगर आपका painting, if you feel there is a value associated with it, इसको आप commercialize करना चाहते हो, so then only protect it and it would help.
That is not commercialized, just it was done as a hobby. Another question, sir. I have done my PhD in computer management last year. So just wanted to do certain kind of patent filing related to my research work.
Yeah.
So I had asked the question in the previous session. So sir has told that it would be done with the help of the organization and all. So if it is possible, is it possible to do that particular patent filing individually, and how much it will be costing? And if it is required to make a number of participants, or you can say contributors?
Yeah, so ma'am, I can very effectively answer this. Firstly, once I go through your invention, then only I'll be in a position to answer whether uska patent mil sakta hai ki nahi. Second thing, there can be any number of people who can be inventor. Uska sirf ek condition hai, they should have contributed to the invention. It is not the principal of the institute or the R&D head or owner of the company who is telling ki ye inventors hai. No, those who have contributed to the invention. Though there are two questions to be answered. Is the person involved in conceptualizing the idea? If the answer is yes, he is an inventor. Is the person involved in execution of the idea? If the answer is yes, then he's an inventor. But then in that case, remember, execution mein, in many cases, chemical lab mein, chemical attendant jo hai, lab attendant, they are also involved into executing. But executing the idea, knowing what they are doing and what is the contribution to the idea, in that case, they can be the inventors as. And coming to your last question about the costing, so of course this is something. I am a practitioner. We file a lot of patents. Rather, we have filed more than 200 patents for academic institutions as such. The costing has been reduced by the Indian Patent Office recently. 80% reduction has been done. But I think this is something which need to be tackled. Not on a public platform, but then जो आपका official fees है, that is reduced basically. But एक patent agent या patent attorney का जो fees है, those would be professional charges, which would be different, I would say. And I believe public platform is not the right thing to.
Yes, definitely.
I have mentioned my phone number in the chat box. Bharti,
Yes, sir, definitely.
You can just ping me and we can discuss it.
Yeah, definitely, sir. I will contact you.
So
Thank you so much, sir. Thank you for a wonderful session.
Yeah.
Thank you so much.
Supplementing to this question, what legal document has to be done for the teamwork?
For the
teamwork?
That's an interesting question. I would say, see, when you say teamwork, as in, for example, if you are, let us say, 4 or 5 people who are developing a product,
no,
who are involved.
Suppose there's a team for overall project.
Yeah.
And then they are going for the patent. Later on, there should not be fight between them. What legal work, a legal document has to be there in between them?
So in between them, there is no document per se is required. Basically, so for example, if there is an institution and inventors, in that case, we have the assignment option, which is available actually. If required, you can have a simple agreement actually. If you feel there may be some issues later, you can have a simple agreement on a simple bond paper mentioning each of the person's role, and you can get that agreement executed. 100 rupees ka stamp paper or 50 rupees ka stamp paper, wo bhi chal jayega, sir.
Only notarization will suffice?
Yes, sir. Yes, sir. I don't think anything beyond that is required per se. Yeah, because honestly speaking, as I mentioned, we have filed more than 200 applications. We have never faced this kind of issues. And in last 17 years, I have never seen this kind of issue. The issue arises, I'll tell you kahan pe. For example, you are working with the institute today, or you are working with a corporate today. You file a patent application today and you leave that organization. And the organization later on comes to know कि आपने patent file किया हुआ था, and that organization wants the rights now. ये common है. But within the inventors, I have not faced this kind of issue. Yeah.
What law permits to get it registered? With what way?
It can be a simple agreement, sir.
Yes, but it has to be registered with the registrar of this one office, or only the simply notarization?
Simple notarization should do, sir. At the end of the day, where are you going to use that?
For patent application.
No, for patent application, so you don't need anything. We have separate forms as per the Indian Patent Office.
And in future, during those 20 years of span, if somebody is saying that I was also this one, idea conception was mine, somebody was contributor, then there will be a legal fight in between them. So, sir, there is a way out that point of time that other person can do. Is absolutely fine. See, okay, to simply answer your question, we in case of our pharmaceutical or chemical research, we tell the institute or the organization to keep the lab notebooks, as simple as that. LNBs जिसे हम बोलते हैं, in which all the experimental details are there. क्योंकि उसमें लिखा होगा who have contributed, and signatures and all are there actually. Yeah, I agreed for that, because organization is a registered legal entity. But what about the individual group members? So, sir, honestly, as I said, we have never faced this kind of issue. In 20 years, if you are saying someone after 18 years would come and say, but then, okay, the burden of proof would be on that person actually. Us person ko prove karna padega कि I was also part, rather than you disapproving he was not. Okay, in that case, the registered document would be a legal document to fight in the court of law. Absolutely, sir. Yes. Instead of notarization. Yes, sir. Yes. Okay.
So many of these are gray areas, so there cannot be answer yes or no basically. Yeah. I think there is also a question in the chat box. How could we identify infringement and how can we stop it further? I think that's an interesting question. तो जब मेरा IP है, मैंने जैसे फॉर एग्जांपल भारती मैम मेंशन की उन्होंने कुछ पेंटिंग किया which is ओरिजिनल पेंटिंग. Now it is her duty to identify कि किसने उसको कॉपी किया. इनफैक्ट जो भारती मैम का मैं पिक यहाँ पे देख सकता हूँ, at the background there is a Ganesha painting actually, for example. तो it is her duty to ensure कि कोई और उसको कॉपी कर रहा है कि नहीं. And how to track that? There are actually, honestly speaking, there are agencies who can do it for you. You don't need to go out and I would say, I mean, there can be some agencies basically who can do it for you. Yeah. Any other questions?
Any questions from the students? All right, we can start.
Yes, ma'am. So thank you so much, sir, for such a informative and interactive session. Now I would like to request convener of EDSISL, Dr. Shilpa Kankonkar ma'am, to propose the vote of thanks. Ma'am, your mic is muted.
Okay. Good evening, everybody. And I think, sir, your session has been very engaging with respect to some encouraging comments coming from everybody. So I think that explanation was very nice. Yeah. At that, yes. At the onset, like I always say, that 1 second, just give me a minute, sir. Sir, am I audible?
Yes, ma'am, you are audible.
Okay. All right. Okay. So at the onset, sir, thank you so much for sparing your valuable time. I know we have been continuously taking follow-up of your availability, and I think it's worth the wait. Your explanations, the way you have spoken about the different type of patents, especially from an awareness point of view, where we have a blend of research scholars and faculty members, and as well as students coming from different streams, not only management. So I think at that time, this kind of a blend, which is very self-explanatory, has really made a difference. And I would like to also take this opportunity to thank our institute director, Dr. Anand Dadas, for having facilitated this entire impact session series, because we were planning actually in the month later on, but then, it was basically, the entire force coming together, and we said, why don't we finish the first series right now and have the second one coming up in the month of July. So that's it from our side, sir. Thank you so much. And in LS, for everybody to know, we are a nodal center for Kapila scheme also, sir, for your information too. And if anybody is interested, they can come and let us know, and we could also facilitate in the process. And sir, at this point, we would also like to have you on board. I will send you the formalities for the Kapila committee also, like I had spoken to you last time.
Yeah.
So thank you so much, sir. And if there are any questions, otherwise we can sign off for the day. And everybody, let us just keep the spirit of innovation in place, so that we can think of contributing to the world around us, to the society around us, and the country at large. Thank you so much.
Thank you, everyone.
Thank you so much, ma'am, and thank you, sir.
I think, yes, sir. And I will be sending you a formal proposal for the your concurrence on the Kapila scheme, and it will be really nice.
Thank you, everyone. Bye.
Thank you, sir. We can sign off. Thank you. The feedback link has been put in the WhatsApp group as well as the chat box. So we would request you to. Thank you. Thank you.